One wrong move with your concealed carry permit, and you're facing a Class C felony, 5 years in prison, $10,000 in fines, and you lose your gun rights forever. And here's the terrifying part. 3 brand new Supreme Court decisions just changed the rules on what's legal and what gets you arrested, and most gun owners have absolutely no idea these changes even happened. Today I'm breaking down 3 Supreme Court gun rights changes that could land you in federal prison. By the end of this video, you'll know exactly which mistakes are now felonies and how to stay legal under these new rulings. This is happening right now to gun owners just like you. In March 2025, the Supreme Court ruled 7-2 on ghost guns. And if you build a firearm from a parts kit in your garage, you could be committing a federal crime punishable by 10 years in prison. 2 more cases are being heard right now that will determine if your concealed carry permit is worthless and whether marijuana users, even in legal states, can own guns without facing 15 years in federal prison. These aren't hypothetical scenarios. Gun owners are being arrested today for violating rules they didn't know existed. Number 1. The Ghost Gun Registration Trap. In March 2025, the Supreme Court ruled 7-2 in Bondi versus VanDerStok that the ATF can now regulate ghost guns as firearms under the Gun Control Act of 1968. Here's what this means for you. If you purchased an unfinished receiver kit or an 80% lower and built your own firearm at home, the federal government now classifies certain parts kits as complete firearms requiring serial numbers and federal registration. You might think you're exercising your Second Amendment right to build your own gun. But under this new ruling, if your parts kit meets the ATF's definition of a firearm and doesn't have a serial number, you're in possession of an unregistered weapon. This is where gun owners are getting trapped. You bought a parts kit legally 2 years ago. You built it in your garage. No serial number, no registration. You thought it was completely legal. Now, under Bondi versus VanDerStok, the ATF can classify that parts kit as a firearm, and suddenly you're holding an illegal weapon. Here's the penalty. Possession of an unregistered ghost gun is a federal crime punishable by up to 10 years in federal prison and a $250,000 fine. That's not a misdemeanor. That's a felony that destroys your life. You lose your right to own guns forever. You lose your right to vote. You can't pass a background check for employment. And here's what makes this devastating. The ATF is actively targeting ghost gun owners right now. Just last year, federal agents executed search warrants on gun owners who purchased parts kits online, and those gun owners are now facing felony charges. Number 2. The private property permission nightmare. The Supreme Court is hearing Wolford versus Lopez right now, and this case will determine whether your concealed carry permit protects you on private property or if you need explicit written permission from every property owner before you step foot on their land. Here's the scenario that's landing gun owners in handcuffs. You have a valid concealed carry permit. You're legally carrying your firearm. You walk into a shopping mall, a restaurant, or even a friend's private property. You think your permit covers you. But in Hawaii, and potentially other states if the Supreme Court rules against gun owners, you just committed a Class C felony because you didn't have explicit written permission from the property owner to carry on their premises. This is happening right now in Hawaii. In 2023, Hawaii passed a law that bans concealed carry permit holders from carrying firearms on private property unless the property owner gives explicit permission. That means even if you have a permit, even if you're legally carrying, if you step onto private property without written consent, you're breaking the law. And here's the terrifying part. Most gun owners don't even know this law exists until they're being arrested. Here's what you're facing. In Hawaii, carrying a concealed firearm on private property without permission is a Class C felony punishable by up to 5 years in prison, a $10,000 fine, and permanent loss of your gun rights. That's not a warning. That's not a ticket. That's a felony conviction that follows you for life. And if the Supreme Court upholds Hawaii's law in Wolford versus Lopez, other states will adopt identical restrictions, and your concealed carry permit will become worthless on private property nationwide. Just last year, a concealed carry permit holder in Hawaii was arrested for carrying his firearm into a grocery store. He had a valid permit. He thought he was legal. The store owner never posted a no-gun sign. But under Hawaii law, he needed explicit written permission, and because he didn't have it, he He's now facing 5 years in prison. Here's how to protect yourself. First, if you live in Hawaii or travel there, assume your concealed carry permit does not cover private property unless you have written permission from the property owner. That includes restaurants, stores, shopping malls, and even private homes. Second, before carrying on private property, ask the property owner directly, "Do I have your permission to carry my concealed firearm on your property?" Get their answer in writing if possible. Third, watch for the Supreme Court's ruling in Wolford versus Lopez. If the court upholds Hawaii's law, expect other states to pass identical restrictions immediately. You need to know the rules in your state before you carry, or you're risking a felony conviction. This next mistake is even more dangerous because it affects millions of gun owners who think they're following the law, but number 3 could send you to federal prison for 15 years. Number 3. The drug user gun ban that's destroying lives. The Supreme Court is hearing United States versus Hemani, and this case will determine whether marijuana users, even in states where marijuana is completely legal, can own firearms without facing 15 years in federal prison. Here's the trap that's catching gun owners off guard. You live in a state where marijuana is legal. You have a medical marijuana card, or you use recreational marijuana occasionally. You also own firearms. You think you're following state law, but under federal law, specifically 18 U.S.C. 922 G3, if you use marijuana, even legally under state law, you are an unlawful user of a controlled substance, and possessing a firearm is a federal felony. This is where gun owners are getting arrested. You're at a traffic stop. The officer smells marijuana. You admit you have a medical marijuana card. The officer asks if you own guns. You say yes. That officer just handed you a federal felony charge. Or here's another scenario. You're filling out ATF Form 4473 to purchase a firearm. Question 21, E asks, are you an unlawful user of marijuana? If you answer no and you use marijuana, even with a medical card, you just committed perjury on a federal form, which is a separate felony punishable by 5 years in prison. Here's what you're facing. Under 18 U.S.C. 922 G3, possessing a firearm while being an unlawful user of marijuana is punishable by up to 15 years in federal prison. That's 15 years for owning a gun while using a substance that's legal in your state. And the ATF doesn't care if you have a medical marijuana card. Federal law supersedes state law, and marijuana is still a Schedule 1 controlled substance under federal law. Just last year, a gun owner in Colorado, where marijuana is completely legal, was convicted under 922 G3 for possessing firearms while using medical marijuana. He had a valid prescription. He thought he was protected by state law. He's now serving 12 years in federal prison and lost his gun rights forever. Here's how to avoid this life-ruining mistake. First, if you use marijuana in any form, medical or recreational, you cannot legally own firearms under federal law, period. That means you must choose marijuana or guns. You cannot have both. Second, if you're filling out ATF Form 4473, answer question 21, E honestly. If you use marijuana, you must answer yes, which will disqualify you from purchasing a firearm. Lying on this form is perjury, which is a separate felony. Third, if you currently own firearms and use marijuana, you need to stop using marijuana immediately or transfer your firearms to someone who can legally possess them. Do not wait for the Supreme Court's ruling in United States versus Hemani. The law is clear right now, and gun owners are being prosecuted today. Now let's recap these 3 Supreme Court changes that could send you to prison if you're not careful. Ghost gun registration trap. If you built a firearm from a parts kit without a serial number, you're facing 10 years in federal prison and a $250,000 fine under the March 2025 Bondi ruling. Private property permission nightmare. Your concealed carry permit doesn't protect you on private property without explicit written permission in Hawaii. And if the Supreme Court upholds this in Wolford versus Lopez, other states will follow. 5 years in prison and $10,000 fine. Marijuana and guns felony. If you use marijuana, even legally under state law, and own firearms, you're violating 18 U.S.C. 922 G3 and facing 15 years in federal prison. The Supreme Court is hearing United States versus Hemani right now. Any one of these mistakes could cost you thousands in legal fees, your freedom, or your right to own guns forever. These aren't scare tactics. These are real laws with real penalties, and gun owners are being arrested right now for violating rules they didn't know existed. Don't let confusion about gun laws put you at risk. Subscribe to Guns Law Guide so you never miss an update that could keep you legal and protected. I break down complex gun laws every week so you can carry with confidence. Hit that subscribe button and turn on notifications, because the next Supreme Court ruling could change everything again. Next video, I'm covering the 5 concealed carry mistakes that get law-abiding gun owners sued for everything they own. You won't want to miss it.